as this is an interlocutory application to the main trial, I wish to refer this honorable court to the case of is mehleng and another versus the Director of Public Prosecutions. It's civil application 425 of 2020. In that case, my lady, there was an attempt by the DPP to join the two applicants, Mr. Mehleng and Mr. Qosoang, in an ongoing trial that was pending before Justice Ts'ehla. The two applicants brought a separate application in the High Court, civil application. In the High Court.
Ongoing, you mean they had pleaded?
No, they have not yet pleaded, but the matter has already been indicted and pending.
So that's why you're saying ongoing?
Yes, my lady, ongoing. But yes, it was pending before Justice Ts'ehla. So they wanted the court to block the DPP from indicting them in that case. And the application was dismissed because what Justice Sakwan said in that matter was,
you mean Mehleng's application?
Mehleng's application was dismissed. And amongst other reasons was that you ought to have referred or launched the application before the trial judge. In other words, in criminal trial 001 of 2018 for determination on this aspect. In other words, you cannot bring a separate application to challenge something that is pending before another judge. So the cause before you, my lady, is in order. It cannot go to a separate judge because it is now pending before you. So the court has to decide this issue before proceeding with the trial. That is the rationale, my lady, why that decision of the application that was launched by the two applicants was dismissed.
Are you addressing my concern that I'm already ceased with the matter?
Yes, my lady. So the court.
Yeah. So if Ts'ehla, Justice Ts'ehla,
yes, my lady,
was already ceased with that matter.
The criminal trial.
The criminal trial.
Yes, my lady.
And then here is a separate application.
Yes, my lady.
Relating to the Ts'ehla matter. I mean the Justice Ts'ehla's or the case before Justice Ts'ehla.
Yes, my lady.
And then the applicant in the separate application is referred back to the court which is handling the main trial.
Yes, my lady.
So how do you connect that to the present scenario where the court is saying I feel like I'm already ceased with this matter?
Yes, ma'am. You are ceased with the matter?
Yes.
There's an issue.
Here is an application.
Here is an application.
Yes. Can this application come at this very stage?
Yes, ma'am.
And be justiciable?
Yes, my lady. Oh, certainly. But
after the court already assumed jurisdiction over the matter.
No, my lady.
And actually, it's not about jurisdiction because
thank you, my
the
lady.
court. It could be argued. In fact,
yes.
that's what the Crown has argued, that
yes.
they have, like, this court has unlimited jurisdiction.
Yes.
But of course, it's known that there will be exceptions.
That is correct.
Exclusions.
That is correct, my lady.
Statutory exclusions.
Yes, ma'am.
Yeah.
My lady, the point that
so how do you connect
that a legal point that emanates from pending trial before that judge, it must be determined and dealt by that particular judge. There's a trial pending before you. Now there's a question whether this matter was properly remitted here. The very same case that is before you. Now there's a question. That question has to be determined by you before proceeding to the trial.
Yes, now I'm asking. Yes, there's no harm about it.
Yes, ma'am.
The question is it the right time for this kind of application?
Thank you, Malik.
To be before this court that is already ceased with the matter. can I renege from the matter and say, okay, yes, you know,
don't know, my lady.
yes, it's not properly before court, so I have to take it out of this court at this stage.
Yes, my lady. My lady, it being a point of law, whether the DPP exercised her discretion as envisaged by the law to remit the matter before this court, you are entitled to deal with that issue before proceeding with the trial itself. It's a question of law of the person who has been conferred with such powers. It's like a point of non-joinder, my lady. Parties can argue the matter here, and when it arrives in the Court of Appeal, they said, well, we feel like there's a point of non-joinder here, which was not addressed by the court. But it's a point of law. It can be addressed even for the first time in the Court of Appeal. So there's nothing, my lady, that prevents you. Before, that's why I started by saying the accused had not been called to plead. So there's nothing that prevents you, my lady, from dealing with and deciding this interrogatory application.
Yes.
Thank you, my lady. My lady, our point is very brief. It's a non-compliance of Section 144 of Criminal Procedure and Evidence Act. My lady, this being review proceedings, the first respondent ought to have dispatched the record in terms of Rule 78(2)(b) upon receipt of an application. There has been a concession by my learned colleague that the record does not exist. That issue is very important, my lady, as I shall shortly indicate. Another pertinent issue, my lady, is the fact that it is common cause that the indictment, should I wait, my lady, so that you can take, I'm aware that the sun is,
I'm trying to look at the other side.
I think it's better to suggest, my lady. Thank you, my lady. The other pertinent issue is the fact that, my lady, it is common cause that the decision to indict was taken and made by the incumbent DPP.
Yes.
But the answering affidavit in opposition to the present application has been deposed by the acting DPP. And my lady, our submission will differ from my learned colleague, Advocate Manyegoli, that you must ignore the affidavit. Our point is that the acting DPP is not in a position, in any manner whatsoever, to inform the court that there was a compliance of Section 144. The manner in which this section, my lady, is drafted, A and B, it says, whenever, in the opinion of the Director of Public Prosecutions, any danger of interference with or intimidation of the witnesses exists, that is the first criterion. When it's in the opinion of the DPP, can the acting DPP come before you and say, the DPP considers 1, 2, and 3 in the absence of the record. But let us submit that whatever justifications or factual allegations that may be made by the acting DPP is inadmissible hearsay evidence, which cannot be accepted. So, insofar as it relates to what the DPP considered to indict the matter, the acting DPP is not in the position to inform the court what was considered. That can only be done by the incumbent DPP. Now, the matter is even worse because it is complicated by the fact that there's no record. It would be a different story if there was such a record. And my lady, in terms of the decision is in qosoang, I'll supply the court with the copy. In qosoang versus National University of Lesotho, it is reported in 1985 to 1989, LAC, 1985 to 1989, LAC 369, and in particular at 383. This judgment, my lady, is an authority for the proposition that in law, a witness cannot rely on the statement made by a non-witness if such statement is to be used testimonially. That is, if such a witness is to rely on the statement as proof of the truth of the contents as against it was in fact made as aforesaid or tendered to prove that it was made. So the acting DPP deposes to an affidavit to say the DPP considered, it was in the opinion of the DPP that the matter should be remitted. To say the DPP considers in the interest of state and public, in the safety of the state or in the public interest, to have the matter indicted. She is not in a position, my lady, to say that in terms of this decision. And my lady, if we are successful on that proposition, that should be the end of the trial before. It must automatically be remitted back. The last issue, my lady, which we have raised in our heads of argument, while we concede and accept that the DPP has got a discretion and power to direct where the case should be prosecuted, but that discretion is not limitless. It must be confined to the law, what the law says. And my lady, I have already read section 144 A and B, and we submit, my lady, that there's no iota of evidence before you that there was such compliance. In other words, there are no jurisdictional facts to prove that indeed the DPP complied with section 114A and B of the CPME. And my lady, once there's no such proof, we submit that this is a clear indication that there was abuse of exercise of power by the office of the DPP. The DPP being a creature of statute, she cannot, when she desires, willy-nilly, just decide to indict the matter in the High Court. That cannot be so. That could not have been the intention of that legislation. This is exactly what happened, as Mehleng had called it, tabulated the facts, what happened in court.
By the way, I haven't not asked why it is that you particularly counsel for the second
Yes, Mehleng.
are bringing this matter.
I answered that question, Mehleng, on Monday.
No, you didn't. Did you?
Yes,
What did
Mehleng.
you say?
I would say. Mehleng, I say it was an oversight on our part. But we felt, as an officer of court, once this important issue is being brought up, then we must join and assist the court. That is the reason why I'm here, as the court pleases. Lady, having said that, we submit that the matter should be remitted back to the subordinate court. More so when the acting DPP accepts that the subordinate court has got jurisdiction to deal with the matter that is before you. Lady, we submit that the cost should follow the events, and should we be successful, we request that we are entitled to cost. Well, lady, that is as far as I can take this matter, and I will I will furnish the court with the decision in qosoang and the Rame Pane matter that we had referred to in our heads of argument. I think also there are some important quotation from that decision where the several judgments are being quoted, dealing with the discretionary power given by an institution just like the office of the DPP. That is all, my lady, unless there are questions.
The DPP also come upon the accused person to make representations before the decision is made.
Yes, my lady. If
You agree with
I agree with the arguments advanced by my learned colleague, my lady, which, as he had indicated, the prejudice that his client suffered. He was able to secure the services of the King's Counsel in the matter. There was no query that the matter would, for some time, the King's Counsel would not proceed. But all of a sudden, the matter is being indicted here. And the court's record will reflect, my lady, that Advocate Pafani Casey, he had been initially attending until a certain stage where the court was then informed that because of the instructions, he is unable to proceed with the matter. That on is also, my lady, is very prejudicial. And since the court has asked this important question, and that is not the only consideration, my lady. In terms of the decision of Mda, it says, if the matter does not commence in the subordinate court as it should, and is now being taken before the court, should the accused in that matter not be satisfied with the outcome of the court, their right to appeal is only limited to the Court of Appeal. That is also another prejudice, my lady. Their rights to appeal is limited to the Court of Appeal. When the matter which would ordinarily be justiciable in the subordinate court, then it's all of a sudden in the morning when the matter was supposed to be heard, I cannot even recall. But when we appear in court, then the DPP simply says, "Oh no, we are no longer here. We are in the High Court. I've got powers." That's an abuse of the discretionary power, my lady, entrusted upon that office, as the court places me.
Right.
Next, please, Madam.